Hello everyone and welcome to this video tutorial in which we're going to be doing some A-level law revision. We're looking at contract law today and privity of contract. Some students find privity a little bit tricky when they first start looking at this area of law, so hopefully this video will be really helpful to you. So we're looking at an evaluative essay question today, and the question is here on the screen. So it says, it is clearly desirable to amend the rule that a third party may not sue on a contract which is made for his benefit. Discuss. And I've taken this from a past exam paper, and some students found this a little bit tricky because the question itself doesn't actually use the word privity. Quite often an exam question will include the word from the name of the topic. So it could have been phrased, discuss whether the law on privity of contract is fair or not. Obviously, this question's phrased differently and would have expected the students to be able to deduce that this is actually about privity of contract. Because privity of contract is a fundamental principle in contract law, meaning that only the parties to a contract can enforce its terms. And that's represented in our diagram here, because you can see in this picture, these two characters are forming a contract, and this party here is representing a third party. So the general rule is that this third party can't enforce this contract because they're not a part of it, even if this contract has been made for the very purpose of this third party. So this question is asking you to discuss really whether that rule of contract law, this privity of contract rule, whether it's fair or not. As always, I've got a suggested answer for you here, and as usual, I've colour-coded it. So the black font represents assessment objective 1, where you're explaining a rule, a principle, a case, or a fact. And the red is AO3, Assessment Objective 3, where you are actually analysing and evaluating the law on this area. And I've also highlighted the cases just to make them a bit clearer on the screen for you. It's nice to start your answer with a definition. So even though the question doesn't mention privity of contract, we've worked out that it's about privity because it mentions that there's this rule that a third party can't sue on a contract that they're not a party to. So we know it's privity, so we're going to start by defining privity of contract. So privity means only parties to a contract can sue each other. Third parties cannot sue on a contract they are not a party to. And you can see that I've gone into red font because I'm now starting to analyse and evaluate that rule that I've just explained. So on the plus side, the rule that no one except a party to a contract can be made liable under it is generally regarded as just and sensible, because firstly, parties should be free to make contracts with whoever they wish, and they shouldn't incur rights and obligations unless they've agreed to be part of the contract. So that comes back to the classical rule of contract law, freedom of contract. Secondly, it's unfair to allow a person to obtain the benefit of an agreement when they've not provided any consideration. So this third party here hasn't provided consideration for the contract, so it seems fair that they shouldn't be able to sue on it. And I've got the third advantage here, is that it's unjust to allow a party to sue if they themselves cannot be sued. That would seem unfair on the face of it. So I've started with some positives. I'm now looking at a disadvantage of the rule. So, however, privity has been subject to considerable criticism, and this is referring back to the question here, which is wanting us to discuss that we should perhaps get rid of the rule. So it has been subject to considerable criticism. It may cause inconvenience where it prevents the person most interested in enforcing the contract from doing so. And there are, if you've watched my other video on privity of contract, there are many exceptions to the privity rule. And those exceptions have developed to make the law fairer. But the problem with that is whenever you start creating exceptions to a rule, is that the law becomes complicated. And therefore, many say that the rule, sorry, I've missed an L there, should be abolished altogether. So we've got a definition, we've got some positive things about it, and we've also got a negative comment that's referring back to the question. So let's start to have a look at the different rules on privity of contract. So the general rule on privity is seen from the classic case of Tweddle and Atkinson. And it's useful to just outline very briefly the facts here, just so you can show that you understand the rule. So in Tweddle, a groom was unable to enforce a contract that was made for his benefit. So the contract was for him to benefit from, but because he wasn't privy to the contract and consideration did not move from him, he was unable to enforce it. Now, many people have criticised the case and said that the case is unfair because the clear intention of the men who had made the contract was that they were making it for the groom. It seems wrong that the court is effectively ignoring the intentions of the contracting parties. We could then look at the case of Dunlop pneumatic tyres, where the House of Lords again enforced the privity rule that we saw in Tweddle. And in Dunlop, there was held to be no contract between Dunlop and Selfridge, and therefore Dunlop couldn't sue. This decision seems unfair because it permits a party to accept the benefit of an agreement without performing its obligations. You shouldn't have allowed Selfridge to sell at a lower price. And the judge in the case said that it allows a party to behave unconscionably and shamelessly avoid the consequences of an agreement that he's freely made. And Lord Denning, surprise, surprise, he also disagreed with the decision, stating that in his opinion, anyone should be able to sue on a contract made for his benefit where he has a sufficient interest in it. So referring back to the question at the start, these two judges in this case clearly are of the view that they don't think that the privity rule is fair, and they do think that it should be amended. So Denning being Denning, he wanted to do something about it. He recognised the injustice of the privity rule and the commercial inconvenience of it, and he did try to abolish the rule in Beswick and Beswick. In Forster and Silvermere, Dillon J described the rules as, and I've got a quote here from a judge, it's always nice to include a quote if you can, as, quote, a blot on our law and most unjust. So again, another judge referring back to the question that again, they seem to think that this rule is problematic and should be reformed. Further problems are that a person receiving defective goods as a gift may not sue because, of course, they've not bought the item themselves. And it can also lead to extended litigation due to a chain of contract claims. And in 1996, there was a Law Commission consultation paper that also argued for reforming the privity rule. Because of these problems and the injustice of the rule, a number of exceptions have been created, and the sheer number of them, and the exceptions come from statutes and some of them come from common law. And because there's so many, they make privity legally complex. So let's have a look at some of the exceptions then. So the first exception was found in Dunlop and Lambert, where the House of Lords held that where goods had been lost at sea, a consignor could recover substantial damages, even though the goods, by the time of the loss, had become property of the consignee. A more common exception that you're likely to come across, though, comes from the Contracts Rights of Third Parties Act 1999. And this act came about largely as a result of the work of the Law Commission. They'd written that report in 96. And the point of this act was to give third parties for whose benefit a contract was made the right to sue on it. And the act is very restrictive. It can only be used by a few third parties, and it doesn't apply to all contracts either. The act narrows third party claims to those whom the parties intend to confer an enforceable legal obligation. Arguably, it would be with Tweddle's case if he'd have been named in the contract. If this act had been about then, arguably he'd have been able to enforce the contract. And it's useful to look at some cases on this. So I've referred to section 1.1 and the fact that the third party must be expressly identified, like in Nissin shipping. The Act doesn't help those who fall outside its ambit. So that's a critique, that's why it's in red there. There are other statutory exceptions as well, and I've included a couple of examples here, like the Married Women's Property Act and the Road Traffic Act. The fourth exception to the privity rule are collateral contracts. And a collateral contract is where one party is induced into entering a contract as a result of a promise made by a third party who is not a party to the contract. And you'll have seen that in the classic case of Shanklin Pier. And in Shanklin, the claimants hired a contractor to paint Shanklin Pier. The claimants told the contractors to use a particular paint because the makers of the paint said it would last 7 years. But unfortunately, the paint only lasted a few months before it chipped off. But there was held to be a collateral contract in that case. And the fifth exception is agency, and we can see that in New Zealand shipping. An independent contractor could rely on a clause, in a contract that they'd not been privy to because they were acting as a trustee or an agent. And you could use the case of Leopold Walford as an example of a trust exception to the privity rule. So I'm starting to reach a conclusion here. So the fact that there are so many exceptions to the privity rule makes it questionable whether there are any advantages to it at all. And attempts to avoid privity's injustices are so numerous that the rule itself was made impractical and unfair, and the Law Commission describes the law as, quote, artificial, uncertain, and complex. So you can see here that by going through the different rules on privity and the different exceptions and referring to attempts by the different judges to try and get around the law, that we've effectively answered this question, that there is at least a strong argument that it's desirable to amend the rule so that a third party can sue on a contract that has been made for his benefit. I'm just going to scroll down to the bottom here because you perhaps saw this mark band grid at the bottom. Now this is for the EDUCAS exam board. If you're with a different board, you can just disregard this. Remember that whatever exam board you're with, the law on privity is the same. So the cases, the facts, the evaluation is all the same. But if you are with EDUCAS, you can have a look at your answer and think, you want to be up here for AO1, the black font, and you want to be up here for AO3, the analysis and the evaluation. And just by colour coding your writing, colour coding your essay like I've done, that can be really helpful for you to mark your own work and to see, okay, I've not got much AO1, so I'm going to be perhaps lower down here, but I've got lots of the red, and it can really help you to improve your essays. So I hope you found this video on privity helpful. Do remember that I've got other videos on my channel, not just on contract law, on other areas, and hopefully they'll help you with your exam preparation too.